Corey Brewer from the Wisconsin Institute for Law and Liberty is standing by on the Homesteader Store hotline. Good people with the right stuff. Kubota LS Tractor and Cub Cadet. And before I get into anything, Corey, everyone should go to the website will-law.org. And if you have the means, there is a donate button. You guys do such wonderful work that if people can support you and don't realize that that is an option for them, I just wanted to let them know. Good to have you on the program.
Well, thank you. Thank you. Yeah, we're very blessed to be able to do the work we do, advocate for parents and for transparency. And we wouldn't be able to do that without your support. So yeah, we appreciate it.
There's the new Equality for All project that we talked about last week. Just go to the website. I mean, Will is fighting on everything from, election integrity to school choice to parents' rights in schools and a whole bunch of stuff in between. All right. So let's talk about this situation in Eau Claire. This didn't seem like it should have been that hard of a lift. A school class was called together to listen to a pre-drafted statement. Who knows who drafted it? And then so that the students could understand that their teacher was about to undergo gender transition. And all the parents wanted to know was, what was the statement my child was read announcing this teacher's transition, whatever. And the parents couldn't get it. So, I mean, what's going on here, and why are you guys needing to be involved?
Right. The lawsuit that we filed today, and our client, one of the moms in the district, filed today, is really about transparency. It's an open records lawsuit. Parents simply want to know what was told to their children, and you make a really great point. We're here today because it was ultimately a scripted statement that was read to students. This is in elementary and high school. This announcement was also made to middle school students. And parents just want to know what was read to their children. They want to be able to have this discussion with their kids. And right now they're being stonewalled by the district, and they want this information, so we stepped in.
So the parents are now wondering, prior to this, they just wanted to know what was read. And now that they can't get it, they're saying, well, geez, what did you include in this statement that you don't want me to read? And it's a good sense, by the way, because if the statement were innocuous, hi, Mr. Smith is going to become Miss Smith, which is, it's obnoxious, but that's not terribly weird. That would be no big deal. You would just turn it over. But the attorneys now for the district, this is Eau Claire, are saying, oh, well, we have to investigate whether or not any missteps were made in the drafting of the statement. And so, sorry, now it's an official investigation. You can't have access to this information.
It is a entirely reasonable position to have question raised by why hasn't this been produced yet? And we don't know if the district is simply dragging its feet, doesn't know, that it needs to produce this in compliance with open records laws, not just parents' rights to know, but open records laws too. And we don't even know what the investigation is really about. They say it's surrounding the events and how this was, announced to children, but we don't know who is being investigated, what policies maybe were violated, how long it's going to take, when it started. And here we are almost 2 months now after the statement was read. Probably a lot of parents don't know that it was read at all unless their kids told them. And of the ones that do, they don't have any details yet about what the district told their children. So this is really about helping parents enforce their rights.
Can you deny a parent's right to an open record, to a public record, by claiming not a public record about a personnel issue or anything like that? We're not talking about somebody, but even if we were talking about somebody whose job might be on the line, this statement is not something that seems to me that should be blocked under a, quote, investigation, whether it's a personnel investigation or not. But it doesn't sound like it's a personnel investigation. So it sounds like the lawyers are snowing the parents by making them think that they don't have a right to the record because of an investigation. Is that something that is typical? Is that something that that has any basis in the law to deny access because of an investigation?
You make a really, really great point. And, that's part of the reason why we wanted to step in. I'm really glad that we heard from parents that this request was denied, this information was not being provided, because we've talked about this before, but there's a power imbalance there. The district has its legal counsel, and parents maybe don't know exactly what their rights are. And here, we don't think the exception that the district is using actually applies. In fact, we think that a district read to multiple classes of students, elementary school to high school, in a public school, which is a government entity, by the way, that's exactly the kind of document that's subject to open records law. And whether or not it's tangentially related to this apparent investigation that's ongoing, it's something that parents have a right to have access to.
Yeah.
So that's why we wanted to step in here.
And if there's a violation of district policy in the statement that was read to the whole darn district, that's not a reason to not release it. That, if anything, is a reason to release it so that parents know whether or not they need to take action.
Yeah, the exception that the district is using, and you've kind of alluded to this, it's more often triggered by if there's an investigation going on and we're talking about an employee's personnel file, or maybe a document created as part of an investigation, or something
Yes.
that, students weren't exposed to yet. But here we have multiple minor students being read a scripted statement, and parents don't get to know what their kids were told. And we do not have to be at this point if the district would have just provided that statement.
Something's in the statement. That's what the parents are worried about. And if the district wants to disabuse those parents of their worry, then just release the statement. So you've asked a judge to order the district to cough it up. By the way, one of the excuses before it was an investigation was, it was only oral. It was orally delivered. It wasn't written down. So this was just spoken. They were trying to make people think that nobody bothered to type it out on a piece of paper. So now they're saying, sorry, no, really, it's an investigation. This sounds like a snow job.
Well, we raised that in our letter to the district, and this is public. And we're not saying the district did this in this case, but I think it begs the question, if the district doesn't want to release a document to parents, to taxpayers, whatever it may be, can they just say that something's being investigated and now this document is exempt? That can't be right.
Yeah.
It just can't be right.
When are you going to go before the judge?
We don't have a date yet. Generally, these open records cases move a little bit more quickly than other litigation, and parents want answers before the new school year starts. So we're hoping to have a decision soon that either a judge requires the district to produce the script, or the district does it voluntarily.
Yeah, it's almost 2 months. Next week it'll be 2 months, and they can't cough up this one statement that supposedly is, age appropriate for all of these kids. Corey Brewer, this is one, I think everybody ought to be watching here, because I think you're going to be successful. And as far as the judge goes, this should be a layup for a judge to say, yeah, release the record or don't release the record. Should be pretty easy to make the call on this one. I do appreciate the work and the time on the program today.
Well, thank you very much for having me on.
Good to have you. And Wisconsin Institute for Law and Liberty, you can find them online at will-law.org.